ever been watching a courtroom drama, maybe? Or even just listening to a heated debate, and you find yourself thinking, okay, hold on, who actually has to prove this? Or maybe, if nobody proves anything, who just loses? Self. If you have, then you've actually been thinking about a really fundamental legal idea, the burden of proof. Now, the idea of proving something sounds simple, maybe intuitive, but the way the legal system handles it is, well, it's a lot more complex and frankly more dynamic than most people think. So today we're doing a deep dive into this whole concept. We're looking specifically at India's new law, the Bharatiya Sakshya Sanhita 2023, BSA for short. And you should know, this PSA, it largely carries forward the core ideas from the older law, the Indian Evidence Act of 1872. So we're really talking about principles that have been around for a long time.
Absolutely. And our mission today really is to give you a clear path through this. We want you to understand how courts figure out whose job it is to present the facts. We'll look at the mechanics, sure, but also some really fascinating real-world effects. You'll see how these rules actually help shape public policy and even push towards social justice. It's quite something.
Okay, so let's start with that core idea. When you're watching that show and wondering who proves what, it all kind of starts with this old principle, Onus Probandi. Even the Latin sounds serious, doesn't it? It literally means the burden of proving.
Exactly. And the fundamental rule, it's laid out right there in Section 104 of the BSA. It says, let me get the gist. Whoever desires any court to give judgment as to any legal right or liability dependent on the existence of facts which he asserts must prove that those facts exist. So in, plain English, if you're the one making a claim in court, you're usually the one who needs to back it up. You need to prove it. The maxim is really simple. He who asserts must prove.
Right, that seems straightforward enough. But okay, here's where I think it gets a bit tricky sometimes. Because this burden of proof, it actually has two different sides to it, doesn't it? And they work differently during a trial. There's the legal burden. People sometimes call it the burden of persuasion or the ultimate burden. And this one, you're saying it never shifts. Is that right?
That's absolutely correct. It always stays with the party who would lose the whole case if no convincing evidence was presented at all.
Okay, so for you listening, think about criminal cases. The prosecution always has that legal burden, right, to prove guilt beyond a reasonable doubt.
Precisely. And in civil cases, it's usually the plaintiff, the person bringing the lawsuit.
Yeah.
They have the legal burden to prove their claim, typically on a balance of probabilities.
Okay, so that's the legal burden fixed. But then you mentioned a second aspect.
Yeah. Yes, the evidential burden. This is the burden of producing evidence. Now, this one is much more dynamic. It can shift back and forth during the trial. It's really about who needs to come forward with some evidence on a particular point at a particular time.
Ah, I see. So once one side puts forward enough evidence to make a point seem plausible.
Exactly. Then the responsibility, the evidential burden, it shifts to the other side to respond, to produce some counter evidence.
Can you give us an example, maybe, to make that difference really clear?
Sure. Let's think about that legal burden as the ultimate finish line. You absolutely have to cross it to win. The evidential burden, though, it's more like who's carrying the ball at any given moment in the game. Yeah. So say A accuses B of a crime. The legal burden is always on the prosecution representing A to prove B's guilt beyond reasonable doubt. That never changes. But if the prosecution presents, say, witness testimony placing B at the scene, well, the evidential burden might then shift to B to maybe offer an alibi or some reason why that testimony is wrong. See the shift.
Yeah, that makes sense. Or it is a civil case, like owing money.
Right. If A says B owes him money, A has the legal burden to prove the debt exists. But if A shows, maybe a signed IOU, the evidential burden could shift to B to show, perhaps, that they've already paid it back.
Okay, I think I've got that distinction now. Legal burden stays put. Evidential burden can shift. So the main rule is he who asserts must prove, Section 104. But are there situations where the law itself kind of flips that starting burden, where it's not just about the flow of evidence, but the law says, nope, you start?
Yes, absolutely. Section 104 is the foundation, definitely. But the BSA, like the old act, recognizes certain exceptions. These are situations where the law shifts or even reverses the usual burden right from the outset. And they often come from, well, practicality or just common sense needs in the courtroom.
Like what kind of situations?
Well, take Section 107 of the BSA. It deals with facts, especially within knowledge. The rule here is if a particular fact is known only to one person or is especially within their knowledge, then that person has the burden of proving it.
Ah, okay. Because it would be unfair or impossible even for the other side to prove something only you know.
Precisely. It prevents someone hiding behind unique secret knowledge. The classic textbook example, you often hear this one, is someone caught on a train without a ticket. The burden is on them to prove they actually had a ticket. Because, well, who else would know for sure?
Right. That makes perfect sense. What other exceptions are there?
Another really interesting one is Section 108. This is about proving death of person not heard of for 7 years. So if someone has just vanished and nobody who would normally hear from them has heard anything for 7 whole years, the law steps in and actually presumes they are dead.
It presumes death.
Yes. And because of that presumption, the burden of proof shifts. If someone wants to claim that person is actually still alive, the burden is now on them to prove it. It's a statutory presumption based on, long human experience.
Wow. Okay. What else?
There's also Section 109, which concerns relationships like partners or landlord and tenant or principal and agent. If it's shown that people were acting in one of these established relationships, then the burden of proving that the relationship stopped or doesn't exist anymore falls on the person who's claiming that change.
So it assumes the relationship continues unless proven otherwise.
Pretty much. It avoids making parties constantly reprove things that were already established.
And one more.
Yes, Section 110, about the burden of proving ownership. This one's quite fundamental, too. If someone is in possession of something, a house, a car, whatever the law presumes they are the owner.
Possession is presumed ownership.
Initially, yes. So the burden to prove they are not the rightful owner falls on the person challenging their possession. It reflects that practical idea that possession often does follow ownership, at least until someone proves differently.
That's fascinating. These exceptions really show how the law tries to be practical, putting the burden where the information is likely to be. Now, you mentioned criminal cases earlier, and the prosecution's high burden beyond reasonable doubt. But what happens if the accused person says, yes, I did the act, but it was self-defense, or I wasn't legally sane at the time? Does the prosecution still have to disprove that defense beyond a reasonable doubt? That sounds incredibly hard for them.
That's a great point. And it brings us neatly to Section 105 of the BSA. This deals with what's often called a plea of exception. If an accused person raises a specific defense, like self-defense or unsoundness of mind, maybe intoxication taking away intent, then the general rule is that the burden of proving the facts that support that specific defense falls on the accused.
So the burden shifts to the accused for their defense.
For the defense, yes. But, and this is a really crucial point, the standard of proof they need to meet is lower. They don't have to prove their defense beyond reasonable doubt. Their burden is usually met on a preponderance of probability.
Which means?
It basically means more likely than not. It's the standard typically used in civil cases.
Okay, so it's a lower bar for the accused proving their defense than for the prosecution proving the main crime.
Exactly. It's a significant difference. The law recognizes the accused is trying to establish an exception, not disprove the whole case against them, so the standard is adjusted.
That's a really important balance the law strikes there. It doesn't require the accused to prove innocence, just their specific defense, and to a lower standard. This whole discussion about burdens and proof, it makes me think, how do courts deal with stuff that's just obvious or incredibly common knowledge? Like, does the prosecution need to formally prove that, I don't know, gravity exists in every assault case? It seems.
Inefficient, yes, absolutely. And you've hit on exactly why the legal system has developed two other really important tools, presumptions and judicial notice. These are, let's call them sophisticated legal shortcuts, designed to make trials more efficient and focused on what's actually in dispute.
Okay, presumptions and judicial notice. Let's break those down. Start with presumptions.
Right. So a presumption is basically a rule of law, or an inference, that lets a court assume a fact is true because another related fact has been proven. Think of it as, if fact A is proven, the law might say, okay, we can assume fact B is also true unless someone proves otherwise.
And why do we have these? What's the justification?
Several reasons, really. First, efficiency, avoiding the need to prove the same probable link over and over again. Second, they often align with common sense and human experience, things that are usually true. Third, they can help achieve justice, especially when direct proof is hard to get. And fourth, sometimes they serve specific public policy goals. Basically, they simplify things and focus the court's attention.
And are there different kinds of presumptions, like stronger or weaker ones?
Yes. The BSA itself, in Section 4, lays out 3 types, which signal how strong they are. First, there's may presume. This is discretionary. The court can assume the fact, but it doesn't have to. It can still ask for proof. It's like a gentle suggestion from the law. And it's rebuttable, meaning the other side can offer evidence to disprove it. Think of it as a rebuttable presumption of fact.
Next, discretionary, what's next?
Second, shall presume. This one is mandatory. If the base fact is proven, the court must presume the other fact is true unless and until the opposing party successfully disproves it. This is stronger, but still rebuttable. This is a rebuttable presumption of law.
Mandatory, but still defeatable. Got it. And the third?
Third is conclusive proof. This is the strongest. If fact A is proven and the law says it's conclusive proof of fact B, then fact B is legally considered proven, full stop. No evidence can even be offered to try and disprove it. It's an irrebuttable presumption of law.
Wow. So if something is declared conclusive proof, that's it. Case closed on that specific point.
Pretty much. The law has decided that link is undeniable for legal purposes.
Okay, that covers presumptions. What about the other tool, judicial notice? How is that different?
Right. Judicial notice. This isn't about inferring one fact from another. It's about the court accepting certain facts as true without any formal proof at all. Why? Because these facts are considered matters of common knowledge, or they are easily and accurately verifiable from reliable sources.
Like the gravity example. Or maybe that Delhi is the capital of India.
Exactly like that. Things everyone knows, or things the court can quickly check in an official source. The justification is, again, efficiency, but also accuracy and consistency. It allows the legal system to operate with a baseline of common sense and established reality. No need to waste time proving the obvious.
That's a really clear distinction. Presumptions are logical inferences based on proven facts, while judicial notice is about accepting certain background facts as true without proof. Now, you mentioned presumptions can serve public policy goals. Let's maybe dig into that a bit more. How are they used not just for, say, efficiency, but as active tools to tackle serious social problems, especially specific crimes?
This is where presumptions become really powerful and often quite controversial legal instruments. And typically these kinds of policy-driven presumptions fall into the shall presume category because the legislature wants them to have real teeth. Let's look at Section 115 of the BSA. This deals with the presumption as to abetment of suicide by a married woman. Now, this provision says that if a married woman commits suicide within 7 years of her marriage, and it's shown that shortly before her death she was subjected to cruelty by her husband or his relatives, then the court may presume, this one is actually discretionary, may presume that her suicide was abetted, meaning encouraged or aided by them.
Okay, so the law allows the court to draw that inference, connecting the cruelty to the suicide, even without direct proof of abetment.
Exactly. And the justification here is rooted deeply in tragic social realities. It acknowledges the horror of domestic cruelty, often linked to dowry demands that can drive women to suicide. And critically, it recognizes how incredibly difficult it is to get direct evidence of abetment in these situations. The main witness, the victim, is tragically unable to testify. So this presumption helps bridge that evidentiary gap and serves a clear public policy goal: deterring such cruelty.
That's a sobering example of law trying to respond to a social evil. Is there an even stronger example?
Yes, arguably even more impactful is Section 118 BSA, the presumption as to dowry death. This one is a shall presume, making it mandatory. It states that if a woman dies an unnatural death, not just suicide, any unnatural death within the 7 years of marriage, and it's shown that soon before her death, she was subjected to cruelty or harassment for, or in connection with, any demand for dowry by the accused, then the court shall presume that the accused caused the dowry death.
Shall presume they caused the death? That's a very strong presumption. It essentially shifts the burden quite dramatically onto the accused, doesn't it?
It absolutely does. The accused then has the burden to rebut that presumption, to show that the death was not a dowry death caused by them. The thinking behind this is, again, a direct response to a widespread and heinous social crime. Dowry deaths often happen behind closed doors, making direct proof extremely difficult to obtain. This provision was specifically created to strengthen the law, make convictions more achievable, and act as a very strong deterrent against dowry harassment and violence. It places a significant evidential burden squarely on the accused once those initial conditions are met. It's a prime example of the law using a presumption as a tool for social justice, trying to protect vulnerable victims.
It really highlights how these aren't just abstract legal rules, but mechanisms designed to have real-world impact, sometimes quite forcefully. Okay, let's circle back then to the other mechanism, judicial notice. We know it's about facts the court accepts without proof. Just how broad is this? What kind of things must a court accept as true?
Section 119 of the BSA actually provides a pretty extensive list of facts that the court shall take judicial notice of. They are legally obligated to accept these as proven. It covers a wide range, mostly things that are matters of public record or common knowledge within the legal and governmental system.
Like what, for instance?
Well, things like all laws currently in force in India, specific acts of the UK Parliament that apply, the Articles of War for the Indian Armed Forces, the proceedings of Parliament and state legislatures, the seals of all Indian courts, the accession of the head of state, the existence and flag of countries recognized by India. Also, basic things like divisions of time, geographical divisions, public holidays if they're officially notified, the territories of India, even things like the commencement or termination of hostilities involving the government of India.
And it includes court officials, too.
Yes, the names of court members, officers, legal practitioners appearing before it, and even the rule of the road, on land or at sea.
That's quite a list. So the court just knows all this, or accepts it if presented.
It's obligated to accept it as true without formal proof. But that doesn't mean the judge personally knows every single detail offhand. So Section 119 also provides ways for the court to, well, refresh its memory or verify the information. Section 119, Clause 2, says the court can refer to appropriate books or documents of reference to help itself, especially for things like public history, science, or art.
So it can look things up.
Exactly. And Clause 3 says if a party asks the court to take judicial notice of something, the court can actually ask that party to produce the necessary books or documents to support it if needed.
Right. So it's not about proof in the traditional sense, but about acknowledging established facts.
Precisely. And that brings us back to the key difference from presumptions. Judicial notice is for facts considered inherently true, universally known, or easily verifiable from official sources. The court essentially recognizes reality. Presumptions, remember, are about drawing inferences, logical jumps, from one proven fact to conclude another fact, which might or might not be rebuttable. It's a different kind of legal reasoning.
Okay, I think that clarifies it beautifully. So we've really covered a lot of ground here. We've gone from that basic idea, he who asserts must prove, under Section 104, to understanding the two types of burden, legal and evidential, and how the evidential one can shift. We look at the specific exceptions where the burden starts differently, like facts only one person knows, or the presumption of death after 7 years.
Right. And then we explored those crucial tools. Presumptions may presume, shall presume, conclusive proof, and judicial notice. We saw how they're not just about making courts run smoother or reflecting common sense, but how they are actively used, especially presumptions like those in Sections 115 and 118, to tackle really serious social problems like cruelty to married women and dowry deaths. They become instruments of public policy and social justice.
So hopefully, for you listening, you now have a much clearer picture of how facts actually get established in a courtroom and why it's so important who has the responsibility, the burden to prove what. It's not always straightforward.
Absolutely. And maybe this leaves you with something to think about. How does understanding these mechanics, knowing that the law sometimes presumes facts, especially in sensitive areas, rather than always demanding proof from scratch, how does that affect your view of what's fair or just in the legal process, particularly when those presumptions are designed to protect vulnerable groups or address deep-seated societal issues? It's something worth mulling over, perhaps, until our next deep dive.